Welcome to the fourth panel here, International Human Rights Law, Quo Vadis. So if you were looking forward to that panel, you're in the right place. Just a moment ago, Professor Anguis spoke from here about the relevance of human rights, but also the economic understructure. Now we have, I think, separated both parts, economics on that section, human rights here, but nonetheless, we'll bring both of them together through the presentations. And I really look forward to all these presentations, which fit really lovely together. The first one will be by Dr. Lora Izvorova. She's an LSE fellow from the London School of Economics and Political Sciences, and she'll be talking about dignity, deconstructing dignity to archetypes in European human rights law. Stage is yours.
Thank you, Tugba, and good morning, everyone. It's great to be back in Cambridge. In the paper I'm presenting today, Deconstructing Dignity, Two Archetypes in European Human Rights Law, I address some of the further questions raised by my doctoral research, which examined the meaning and role of dignity in Russia's interpretations of the European Convention on Human Rights until Russia denounced the convention in 2022, as well as how the meaning and usage of dignity by Russia compared to that of the European Court of Human Rights. In my thesis, I arrived at an almost binary opposition, whereby in the court's judgments, dignity means inherent human dignity and has predominantly served to justify the court's expansion of the scope of convention rights. In Russia's arguments, on the other hand, it seems that dignity denotes contingent and conditional status that is dependent on conduct. That binary was helpful to me in the context of a thesis that sought to understand the obstacles to the internalization of the European Convention on Human Rights in Russia. However, when the discussion of dignity is taken out of the context of Russia's problems of compliance, the picture of dignity's role in European human rights law is much more nuanced. The claim I want to make in this paper is that all of human rights law is characterized by the existence and interaction of two archetypes of dignity, inherent and conditional, such that what is different and striking about Russia's approach is not the logic of conditionality per se, but rather Russia's subversion of the relationship between the two archetypes. I will set the scene with a brief overview of dignity's role as a foundational yet contested concept in human rights. Next, I will proceed to discuss the most substantial part of my presentation, namely my conceptual framework with the two dignity archetypes. And then I will bring in some examples from my research and briefly just raise a couple of further questions in the end. So, as is well known, dignity acquired universal recognition as a foundational value for human rights through its inclusion in the preambles of the UN Charter, the UDHR, and most human rights conventions and domestic constitutions after the Second World War. However, the prominence of dignity in human rights discourse owes as much, if not more, to its contested nature as to its universal appeal. At the same time as the declaration was being drafted, UNESCO was conducting an inquiry into the theoretical foundations of human rights, and that inquiry concluded that consensus was impossible on the theoretical foundations of human rights. So the most that could be helpful was practical agreement on what human rights there were. So the reason why dignity made it into the declaration was because everyone could agree that dignity was important, even if no one could agree on what it meant. In other words, the foundational role of dignity for human rights has been that of a linguistic symbol that can represent different outlooks. The ECHR, which is what I'm looking at, is an outlier among human rights conventions in that it does not explicitly refer to dignity. This is despite the fact that the ECHR was closely modeled on the UDHR. Nonetheless, since the case of Ireland against the United Kingdom in 1978, dignity has acquired an important role in the court's jurisprudence and has been established as the very essence of the convention. In a paper I co-authored with Professor Veronica Fikfak in the Human Rights Law Review, we showed that dignity has been deployed strategically by the court to enhance the persuasive authority of its judgments, yet that strategy has been unsuccessful. And we suggested that the differences in dignity conceptions across the constitutions of Council of Europe member states might be a relevant factor here. Now, let me say a little bit about the variety of dignity conceptions, and please excuse me for whizzing through this, but otherwise I will run out of time. We can talk about it in questions. There's a wide variety of contexts in which dignity has been found to be relevant. Looking just at European constitutions, across the board, there is a link between dignity and the prohibition of torture, inhuman or degrading treatment. But from that point on, we see quite a lot of variation. The constitutions of Slovakia, Finland, and Switzerland, for example, also make use of notions like dignified standard of living. And Eastern European constitutions talk about dignity as linked to honor and reputation. So Christopher McRae is one of the scholars that have talked about dignity a lot in their work. And in particular, he focuses on identifying a few different conceptions that have been predominant. And in his 2008 seminal study, he identifies the Catholic view of dignity as humans being made in the image of God, the Kantian dignity based on autonomous moral capacity, a communitarian dignity emerging from Republican theory and Catholic thought, emphasizing duties, as well as a social democratic conception concerned with minimum welfare. For McRae, in 2008, these represented different interpretations of a minimum core concept of dignity, a term he coined. And that minimum core consisted of the claim that each human being possesses intrinsic human worth that requires respect. Some conduct is inconsistent with respect for such worth, others is consistent, and the state exists for the individual, not vice versa. Now, fast forward to 2022, McRae wrote a response to a lecture by the conservative philosopher Alistair MacIntyre. MacIntyre is quite skeptical about the view of the individual as intrinsically valuable. Rejecting the idea of intrinsic dignity, MacIntyre sees dignity as something to be achieved and safeguarded. It can be lost if individuals act against their proper end. He draws a link to Thomas Aquinas and argues that humans' purpose is to know and love God, which directs them to pursue certain common goods together with others. Quoting from MacIntyre now, "No one any longer has reason to treat us as possessing intrinsic human worth. A bad human being is worse than a non-human animal." Again, I'm quoting from him. Putting aside McRae's critique of MacIntyre's provocative remarks, in his response, McRae offers a somewhat different conceptual map of the contestation of dignity compared to what he proposed in 2008. He now identifies a distinction between intrinsic and attributed dignity conceptions as become central to the debate. Intrinsic conceptions are about what it means to be human, and here there are different theistic and secular accounts of the source of inherent human worth and how it should be respected. In attributed conceptions, on the other hand, dignity is ascribed to some individuals conditionally and is associated with status, honor, reputation, and virtuous behavior as a way of earning or deserving dignity. Now, in this paper, I want to work with this distinction, but I also want to problematize it. The frame of reference I'm proposing is less tidy, but I would suggest provides new insights by engaging with the tensions internal to dignity, which go back all the way to the very origins of dignity's intellectual history in the writings of Cicero, specifically his treatise De Officiis, or On Appropriate Actions. Now I'll skip my review of Cicero's vested interests and go straight to what they led him to say about dignity. While humans had a natural dignity based on their superior capacity to reason, which was common and universal, maintaining that dignity required acting according to the moral demands of reason by exercising self-control over desires, drives, and emotions. There was, therefore, a universal element to dignity denoting immanent essence or intrinsic worth, and a conditional aspect to do with decorous comportment or bearing. So as you can see, while the ideas of inherent and merited worth were both present, but they were not conceptually separate, as it seems to have become common in the debate today. They mutually constitute each other and the idea of human dignity. Cicero's ideas obviously did not die with Cicero. They influenced Renaissance humanists, natural lawyers, the drafters of the French and American declarations of human rights, Immanuel Kant, and they, in that way, made it to our discourse today in ways that we're not necessarily conscious of. So I want to stick with this idea. I want to stick with dignity having an essence and a performance aspect which are linked together. And in doing so, by looking at Cicero, but also some of the contemporary dignity scholars that have examined this internal tension of dignity, I want to propose two archetypes, inherent and conditional dignity, which interact in human rights argument, each manifesting to different degrees depending on the context. And in this approach, obviously, I'm drawing on Derridian deconstruction. Now, in the remaining time that I have, this is my preliminary map of how I see the two archetypes in the ECHR and ECHR jurisprudence, and then I'll talk a little bit about how I find them in Russia. So in the ECHR and its interpretations of the by the court, inherent and conditional dignity come together in a personalist approach, based on the philosophy of Jacques Maritain, who was one of the drafters of the UDHR. In Maritain's personalism, the duality of essence and performance, of inherent and conditional dignity, was very much present conceptually, but notably, its results were to make Maritain an advocate for fraternity and pluralist democracy. The human being had an immanent value in that she was made in God's image. In this inherent sense, dignity could not be measured or effaced, and it did not depend on the judgment of society. At the same time, there were certain orders or dispositions discoverable by human reason that prescribed, and I quote, what is appropriate and what is not appropriate. Given that dignity was to be understood in terms of the reciprocal development of the person and the common good. So in the context of human rights, that meant recognizing that individuals also had duties to one another, as Article 29, paragraph 1 of UDHR provides. So again, this is my provisional view of how I see it in the ECHR, and this is obviously not substantively new. We know all that stuff, but the way I want to think about it conceptually, I think is slightly different. So we see the predominance of the inherent archetype in absolute rights, which recognize the inherent value of the human being as such. So with respect to Article 3, let me give you a few examples from Strasbourg jurisprudence. The court has explicitly drawn on dignity to distinguish inherent and degrading treatment from torture. That was the first reference to dignity in the case of Ireland in 1978. Another example, racial discrimination has been found by the court in some circumstances to constitute inhuman and degrading treatment in Cyprus against Turkey, for example. In the context of Article 4, in Rantsev against Cyprus and Russia, the court invoked human dignity to conclude that human trafficking fell within the ambit of Article 4, even though it was not explicitly mentioned. So other than that, I'm inclined to suggest that the general rationale behind the principle of extraterritorial jurisdiction and the positive obligations that the court has read into the convention is also the imperative of protecting the individual's inherent immanent worth as such. However, for the most part, the two archetypes are in some kind of interaction, which makes us feel a little bit uncomfortable, I think, if I put it conceptually like this. So I will list this roughly as a spectrum with the ones that come at the top, as I see them potentially displaying a little bit more of a prominent role for inherent dignity. And as the list goes on, I think conditional archetype is creeping more. So first, there's the court's approach to arguments of waiver of rights. In response to Russia's argument in the case of Anchugov and Gladkov, which is the case concerning the blanket disenfranchisement of prisoners. So Russia argued that violating the law meant that the prisoners consciously forsook many of their human rights. The court didn't like that reasoning at all and was adamant that while the right to vote was not absolute, it was most certainly not a privilege. Convention rights couldn't be forfeited. At the same time, and quite logically, this very reasoning came with the court's acknowledgement that limitations that were justified by valid and convincing reasons were permissible. So indeed, in ECHR jurisprudence itself, there is a waiver of rights that could be recognized in very narrowly defined circumstances. Next, we have the exhaustive list of permissible exceptions in Articles 2 and 5, and then, of course, qualified rights, which in some sense I see as the paradigmatic example of the interaction of the two archetypes. It's almost balanced in this context and closely maps onto the ideas of essence and performance that I have been talking about. Importantly, though, inherent dignity remains the starting point and a key guiding principle when it comes to ascertaining what conditions to the exercise of rights are proportionate. So paragraph 1 of Articles 8 to 11 expresses a right in absolute terms. And then we have the second paragraph providing for conditional respect for the behaviors that express, realize, or perform that intrinsic human interest provided in the first paragraph. So last, I see the conditional type in the second paragraph of Article 10. Perhaps it's most pronounced there because we have the only reference in the Convention to duties and responsibilities. And we have derogations, of course, in Article 15, though we should note that there's non-derogable rights, obviously, and these are the rights most closely associated with respecting the inherent worth of the individual as such. So in the remaining time that I have, I want to tell you a little bit about how I'm finding the two archetypes in the Russia's arguments. So in Russia's interpretations, the two archetypes coexist as well. As I began my presentation by saying, it's not that the conditional archetype is there in Russia's arguments, it's just that it's being subverted. That is my argument. And the relationship between the two archetypes seems to be something different. So once again, Article 21 of the Russian Constitution at least nominally prohibits torture in human integrating treatment. And it has been expanded in federal laws and jurisprudence of the Russian Constitutional Court, again, in formal terms, in similar ways as the European Court of Human Rights has done in its jurisprudence. Yet, the systematic analysis that I conducted during my PhD of all the 401 judgments of the court against Russia between July 2002 and January of 2021, in which dignity is mentioned, revealed that in the Russian government submissions, only lip service is paid to inherent dignity. Even in Article 3 cases, the prohibition of torture in human integrating treatment, which is absolute, an argumentative pattern can be observed where the use of force against applicants by prison guards, police officers, and other law enforcement representatives was being consistently justified by reference to the applicant's disobedience. In other words, conditional dignity. In Russia's submissions to the court, the most relevant domestic provision protecting human dignity is actually a provision of the Civil Code, which requires respect for dignity, honor, and reputation. And what I found was that in the vast majority of Strasbourg cases against Russia, where dignity appears in Russia's arguments, that is to protect corrupt public officials from disrepute. The other groups that emerged as what I call the dignity bearers were Orthodox believers, ethnic Russians, and children, while the performance dignity of, or let me rephrase, whereas the dignity of LGBTQI individuals and individuals speaking against the authorities was being denied in the very same cases. So they are my dignity outcasts, that's what I call them. So two inferences can be drawn from this, and here I'm about to wrap up. So first, we have the element of conditionality that seems to be a lot more prominent than in the ECHR context. And then we have this idea of subversion that I want to briefly talk about. So with respect to conditionality, it's useful to think about in historical terms, I feel. So I looked at the Soviet constitutions and how there's a certain continuation in the way dignity is understood from then on to the narrative about dignity in the Russian Orthodox Church's teaching. And the Russian Orthodox Church is quite an important ideological and political actor in Russia when it comes to the human rights space. So one of the provisions, the key provision of the 1977 constitution that talks about dignity refers to the dignity of Soviet citizenship. So in that constitution, dignity was not something that individuals had intrinsically, they had to acquire it as citizens. So in that approach, duties also came before rights because duties were based on, they reflected socialist values, and it was through them that the individual would acquire dignity. So in the Russian Orthodox Church, what we see is that inherent human dignity is coming into the discourse as an idea, but it's referred to as worth. And it's explicitly distinguished from dignity, which is, again, explicitly referred to as acquired. So while according to the socialist conception of human rights, what was good lies in respect for social values, for the Orthodox Church, what is good depended on what is consistent with traditional values, which we can think of as traditional family, responsibility to society, and national security and patriotism. So my final point, it's the interaction of the two archetypes. So what transpires in my analysis, and I can talk about this further, is that it's not there's no respect for the inherent immanent essence of the individual. The dignity essence is the idea. It's the idea of socialism, it's the idea of traditional values. And what is problematic here is that these narratives have been used to justify state authority. Paul Robinson has referred to that as orthodox or civilizational conservatism that underpins Russian domestic and foreign policy. Timothy Snyder much more critically has referred to it as fascist ideology based on Ivan Gilgan, a 19th century philosopher. So what I find is that the conditional archetype was the only one directly relevant as a basis for rights. So the link there between the two archetypes is separated in this way. And finally, for the questions that I want to tackle in this paper, I want to see if there are any parallels to Russia's approach across the remaining members of the Council of Europe, because I have some intuitions that there are. And if so, then this raises even further questions that should make us feel uncomfortable. So thank you for your attention. Yes.
So much, Lora. And this was a fantastic starter to the panel, breaking down dignity, inherent and conditional dignity. And we will move on here immediately with Dr. Chloë McRae Gilgan.
Yes.
Is that
Perfect.
correctly pronounced? Sorry about that.
No, perfect.
Senior lecturer at the University of Lincoln. She will be talking about the responsibility to protect, Refuge in Peril, the responsibility to protect populations fleeing mass atrocities.
Thank you so much. Well
Thank
done.
you.
Mouthful. I'm just going to time myself, make sure I stay on task. Good morning or good afternoon now. Thank you so much for having me contribute to this great conference. It's been really, really inspiring to hear everyone's research and see how there is a real narrative connection between the presentations. And so I feel that my presentation very much is going to lead on to a lot of what's come before. Today, I'm going to talk about my draft monograph, which is largely based on my PhD research, and then the more recent edition of a US case study. A caveat is that these slides have been updated since I sent them in, so I'm going to skip some just due to the time constraints. I'm going to start with giving some context to the research and then talk about the two protection frameworks that I looked at, the responsibility to protect, known as R2P, and refugee protection broadly, and how these two frameworks overlap conceptually and in practice. I'm then going to share some of the findings on how the US and UK understand their R2P, and how this then affects consensus at the UN Security Council and exacerbates further contestation or resistance of R2P by other states, particularly by the BRICS. The case study focuses on responses to Syria, which as a case was really a catalyst for understanding R2P more broadly. So the case of Syria is largely representative of how these two powerful liberal states envision their responsibility and how it connects to refugees in need of protection. In this way, Syria is not unique. It is a new sort of watershed case for more deeply understanding Western localization and contestation or resistance of R2P. The context of the displaced on the slide is obviously more recent than when I undertook the initial resource, and that's because I'm updating the research. But the important thing to note is that IDPs, or internally displaced persons, are the vast proportion of those displaced, right? Followed by refugees who largely stay within the region of their persecution or war or atrocities, and then a smaller proportion are those that travel to a refugee convention state party's territory to make a claim for asylum. And that will become important contextually in a moment. I realized recently that a common theme in my research is that it is challenge-driven, meaning it starts with a problem that isn't being addressed adequately, or at least in my opinion, it's not being addressed adequately. So this research speaks to what I saw as a deficit in the literature, but also the practice of states during this particular time period. The period at issue was 2014 to 2016, when we saw an upsurge in atrocities in Syria, and we saw overburdened host states proximate to Syria, despite generous aid from the US and UK sort of bursting at the seams and unable to deal with the responsibility. Eventually, that burden was too great, resulting in 1.2 million Syrians fleeing to the European mainland to seek refuge. Now, while Europe was slow to open its doors, say for Germany and Sweden to some degree, arguably, the question became, what is the possible source of responsibility to protect those refugees fleeing mass atrocities, rather than the lower threshold of persecution as designated under the Refugee Convention? And what became important was how the US and UK understood this responsibility that they continued to support. And recently, more recently, two centers for R2P, the Asia Pacific Center and the Global Center based in New York, put out a toolkit for states to respond to atrocity situations, because responses, and particularly consensus over responses, was stalled and failing and continues to be so, regardless of where we are at with Syria. It's across any atrocity case. But what is absent from this toolkit is any discussion on accountability for how states understand and practice R2P. The literature and the political discourse focus on the permanent two, that's Russia and China predominantly, as veto-wielding states that prevent any response in atrocity cases, even humanitarian aid access responses. At the time of my PhD, there was no real consideration of how the P3, the permanent three, UK, US, and France, might be exacerbating this non-consensus at the UN Security Council. So this research speaks to that, the US and UK understandings of R2P and how these states give meaning to that norm, and how that norm then and that meaning has effects and radicalizes further contestation or resistance of R2P by other states, and more largely and broadly and importantly, general atrocity prevention and response, particularly by the BRICS, but also by less powerful states. So leading on from the keynote this morning, this is critical because the P5 have a special responsibility to respond to atrocities because their self-appointed power, perhaps the spoils of war, is to maintain international peace and security. It has been said with great power comes great responsibility, and how this responsibility is wielded is then essential. So there needs to be more focus on how the P3 realize this responsibility. This being said, it seemed this was necessary as both the UK and US had varied responses to Syria, particularly non-coercive responses, which are explicitly required under R2P. So the question became, why are they not linking such responses to R2P? To calm that contestation of the BRICS towards building consensus, particularly post-Libya. So just a quick note on theory and methods for the research. I could talk about the complexity of the theories applied all day. They're really fun. I had to teach myself IR norm theory because I was in a law discipline, but the proper theoretical theory, the theoretical framework to use was really IR norm theory. So I'm just going to give short mention today due to the looming ticking clock that's making me quite nervous. So the theory adopted, that I adopted, was Wiener's theory, first of all, which understands that the meaning of a norm is derived from state practice. I also adapted Acaria's theory on localization of norms to understand how international human rights-based norms find meaning in domestic contexts. That means how they travel from the international realm to the domestic sphere. And that usually sits with political elites. This approach is a critical constructivist approach to IR norm theory, which is traditionally applied to authoritarian or post-colonial states. There's inklings of it across TWAIL, and it's usually used to deepen understanding of how international, which are often seen as Western norms, are modified in domestic contexts due to competition with more dominant domestic norms, which results in then a modification of that human rights-based norm and potential feedback to the international level. Now, this approach was not applied to liberal states, allowing a presumption that international norms find normative tranquility in liberal states, that there is no meaningful contestation or resistance to human rights norms in these Western states. So this research rebuts that presumption and found that some human rights norms undergo contestation at different points, depending on the domestic norms it's competing with, and also depending on the specific time period and what's happened contextually. So, a great example is counterterrorism, right? It's a norm that's going to compete with human rights-based norms frequently in the Western context, in probably all contexts to some degree. In this case, R2P competes with several stronger domestic norms and has become modified to a very narrow understanding for the US and UK, which I'm going to come to shortly. On the methods used, I started with a doctrinal analysis of the conceptual links between the two frameworks. The result was an understanding that there would be some valid argument for seeing the two frameworks separately. However, this was not the reason the UK and US delinked their refugee responses from R2P or any of their peaceful responses either, which gave important information on these states' broader understanding of what R2P means in practice. So for the empirical stage, I first analyzed the official discourse and then interviewed officials to interrogate the underlying meanings of the discourse, particularly where R2P was absent from responses that clearly fit within its remit of peaceful responses. I did this with civil society and other humanitarian organizations as well to understand the advocacy frameworks that were relied upon for increasing refugee protection and responses to Syria more broadly, to further understand the sources of responsibility relied upon, and importantly, why those sources, and particularly R2P, was often absent. So briefly, just for those who do not know, R2P requires all UN member states to respond to atrocities in a manifestly failing state through non-coercive means. That means diplomacy, humanitarian assistance, and peaceful methods. These should be exhausted before any coercive responses are undertaken, such as military intervention under Chapter 7 of the Charter. The use of force is not required. It is merely a possibility. States just agreed that they were prepared to take action, a pretty watered down requirement. The explicit requirements of R2P, however, are around non-coercive measures. So given that the US and UK had several peaceful responses to Syria and Syrians, why were these not linked to the responsibility to protect? And the answer is largely because they selectively delink the peaceful responses in favor of R2P's more coercive response. And this, of course, has effects on the action on the ground. A note that R2P is not a legal norm, but a norm cluster, a political norm cluster, some with roots in law, but it did not change the laws around the use of force. Rather, it aims to create, in my opinion, a more consistent Security Council practice of considering every case of mass atrocity as an international peace and security issue, rather than a selective practice which had occurred up until and through the Kosovo intervention. If atrocities are occurring, then the UN must consider a response. My argument is that the duty is more than Jennifer Walsh's duty to consider, because I believe that there is a duty to respond peacefully and to exhaust these methods, regardless of whether there's consensus around coercive responses. I should also say that R2P's central root is the idea of sovereignty as responsibility, and that comes from the Sudanese diplomat Sir Francis Deng, whose work on this idea is central to the principles of protection around state responsibilities for IDPs. So arguably, the norm is not a Western-based norm, as mistakenly sort of argued throughout the literature, not so much by the R2P hardcore group, but those that maybe practice R2P on the peripheral. If I had time, I'd also talk about Kofi Annan's conceptualization of the UN's purpose as a human rights, as a human rights kind of, as a purpose of human rights post-Rwanda and Srebrenica, which led to endorsement of R2P. That post-World War II predominant purpose of the UN was really about maintaining international peace and security, and human rights were somewhat deprioritized. This arguable paradigm shift was from state security to human security, given the increase in internal wars. R2P was the answer to this, and it was largely based on the idea that there is a common humanity around preventing and responding to the most egregious of human rights violations. I said I wasn't going to say anything about that slide, but I tried to put in a little bit very quickly. So quickly, refugee protection is largely set out in the Refugee Convention and its protocol. Asylum is the hard law aspect of international refugee law, and resettlement is a discretionary norm, which is considered in the Convention's preamble that states should help each other, responsibility share, where certain states will bear the burden as gateways to large flows of refugees. We saw this happen with Greece and Italy during the so-called refugee crisis in 2015, when states like the UK and US were slower to responsibility share for a number of reasons I can't go into. But I do not have time to go into their specific resettlement programs. There are a lot of complexities, not least of all the fact that both prefer resettlement to asylum due to it being discretionary, and it also allows for cherry picking of desirable refugees rather than whatever humans they might find on their territory trying to make that claim for asylum, which is required. If you want to claim asylum, you have to access the territory. So for this reason, the book focuses predominantly on how the resettlement norm links to R2P due to these states' preference. Again, briefly, this slide lays out the conceptual links between R2P and refugee protection. Just suffice to say, an R2P response is in the manifestly failing state. So a refugee who has crossed out of the manifestly failing state is conceptually no longer fleeing mass atrocities unless atrocities develop in the host state, or they are refouled back to the manifestly failing state. Also, fleeing atrocities is a much higher threshold to meet than fleeing persecution, clearly. It is likely that fleeing mass atrocities is probably always fleeing persecution, but fleeing persecution is obviously not the same thing as fleeing atrocities. And it also both can occur inside or outside wartime. There are a lot of complexity within this reality explored in the book, and as I said, I will move on quickly because there are differing regional definitions for a refugee, which would go beyond the convention refugee as well. There is a responsibility to resettle refugees for many political and practical reasons, such as making room in host states as atrocities continue, and also showing solidarity, as we've heard about today, to a global problem. And especially if states are already responding with these refugee programs, there is a reason to link this to R2P because it de-escalates contestation around atrocity prevention and response by warring states and provides an opportunity for building consensus if states see the most powerful states are willing to engage with their responsibility non-coercively. A case in point is that the US and UK repeatedly linked political transition and the rhetoric of Assad must go, which denotes democracy building and regime change, within the UN Security Council resolutions on Syria. And in particular, these items were attached in the early resolutions to getting aid access into Syria, cross-border aid. Once these were delinked from R2P, these resolutions were no longer vetoed by the P2. And there's some complexity within that I can't go into. I'm simplifying a bit, but there is some interesting research on this by Ralph and Gifkins as well. That's my cue to hurry up. So these are some of the findings, just really quickly on what R2P means in practice for the US and UK. I've largely kind of said that. It's largely been modified to be a coercive response that entails a focus on democracy building as the best insurance for preventing atrocities. This is complex, however, as while the common denominator is R2P as coercive, this was also the reason some officials avoid the use of R2P language at all. For example, the FCO, at the time it was the FCO, not the FCDO, saw only a diplomatic response to Syria and wanted to avoid R2P language because they didn't want another Libya. The irony is that attaching R2P to the UK's diplomacy, humanitarian aid, and refugee resettlement program would have de-escalated that contestation and that narrow understanding of R2P and possibly fostered more trust and consensus that the UK does not envision involving itself coercively in every case of atrocity response. It would also help to temper that post-Libya problem that endures. So further findings around how civil society advocate for refugees fleeing mass atrocities generally showed how the frameworks were used as a response basically to how the UK and US understand R2P. So very iterative response. No time to go into that today, but I did write an article about that and some surprising ways that civil society tries to get in the room to advocate for greater protection and some of the shortcuts they use, even to the detriment of allowing a narrow, not so true sort of modification of R2P to endure in order to get in at the end of the day in the room. So it must be said very quickly that using localization as a framework means to some degree accepting that how states practice a norm gives its meaning. However, arguably, this critical approach does not really involve an evaluation of the effects of that localization, right? Instead, it just explains it. So that's something missing from the theory. And this can be quite critical for those needing protection on the ground, because how the UK and US understand R2P is going to have wide effects, broad effects. And arguably, this theory is usually used by less powerful states to understand norm diffusion, right? And maybe those feedback effects do not have as great an impact as when you apply it to very powerful liberal states. And one case in point is this is exacerbated by the fact that both Brazil and China came up with modifications to R2P responsibility while protecting or responsible protection, which were demonstrations of a contestation against the military intervention aspect of R2P. And basically it added additional checks to when coercive force would be used. And of course, the rejection and dismissal of those modifications by the UK and US further exacerbate the idea that the narrow understanding of R2P by the US and UK has been shown to be more coercive. So finally, obviously that affects practice on the ground and consensus. It also provides an easier way of allowing the P2 to hide behind their own human rights violations in terms of R2P situations. So some recommendations stemming from the research. Just finally to conclude, I'm so sorry, to answer the question of where we are going, I would say we need to reconsider Western accountability in instances of hypocrisy on responses to atrocities, to make the forum of consideration more transparent and honest, and to stop providing an excuse for other states to blatantly disregard their violations of human rights. So I think that accountability has come home to roost. Some further publications if you're interested. Thank you so much, and I'm so sorry for that.
I think you mentioned, Chloe, sovereignty as responsibility, and I think that's a base underlining of almost this panel, right?
Yeah.
Yeah, and you're going to talk now about sovereignty and who is actually sovereign? Is it just a state or
Exactly.
the corporation, right? So, Dr. Bethan Hall, Postdoctoral Fellow, Center for International Law, National University of Singapore, will be exploring the human rights obligations of corporate sovereigns.
So thanks. Hi. Yeah, so I'm going to be talking about the notion of corporate sovereignty as a normative justification for imposing human rights obligations on multinational corporations. And at this point, I'll just wave at Professor Angie at the back there and pretend that I'm not very nervous. It's a fact that's readily acknowledged that modern multinational corporations cause unprecedented harm to the environment and human rights. Traditionally, they are not the bearers of human rights obligations, but this has obviously led to significant accountability gaps. And so in response, there have been efforts to establish an area of business and human rights law, but this area of law has had quite little impact, actually, on, the post-1945 system, where states are the primary players and duty bearers of human rights obligations. So in this context, there's two primary ways that you can hold multinational corporations accountable, either indirectly or directly. And so under the indirect approach, it's the state, not the corporation, who has the human rights obligations to regulate the third party, in this case, the business. Obviously, under the direct approach, it's the multinational themselves that has the obligations. The main way that corporations are currently held accountable is indirectly, which obviously reflects the kind of state centricity of international law. But there are significant shortcomings to this model. Theoretically, the imposition of positive obligations on the state to regulate should close the accountability gap, because if all states regulate, it doesn't really matter where multinationals are operating. But practically, the reality is that not all states are willing or able to regulate, these massively powerful multinational corporations. And so the accountability gap continues. Despite the shortcomings of the indirect approach, the alternative proposition to regulate the corporations directly is rarely taken that seriously. And it's because there's significant ideological hurdles to overcome. Like traditionally, human rights are conceived of as limitations on state sovereignty. And so within international human rights law, it's states as sovereigns who are the duty bearers, which is a reflection of the kind of coterminous understanding of statehood and sovereignty, and also, ideas of the kind of public-private divide. And so to challenge these ideas, I turn to history. I look at theories of sovereignty alongside conceptions of the corporation and their operations through history. And the purpose is to challenge kind of accepted notions and expose the operations of the modern multinationals as corporate sovereigns. So the concepts of sovereignty and statehood have generally been treated as coterminous, as I said. But this relationship between the concepts is more a matter of kind of historical contingency than anything that is, natural or necessary. So the original conceptions of sovereignty did not tie it to the state form. the first exposition of the concept is generally attributed to Bodin, who did refer to it as the essence of the Commonwealth. But it was Thomas Hobbes and the Leviathan who gave the concept its main kind of theoretical content, and, you know, declared the power of the sovereign was rooted in the need to escape the state of nature, where, you know, life is nasty, brutish, and short, like we all know. So he said, as a matter of necessity, man would submit themselves to a sovereign power which had ultimate lawmaking authority, was subject to the authority of none other, had judicial power, the rights of making war and peace of the nations, instituting governmental authorities, and doling out punishments and rewards. Echoing Bodin, he also referred to these kind of sovereign powers as the essence of the Commonwealth, but he didn't view sovereignty as statehood as so intimately connected that they were identical. And essentially, it was just this bundle of powers which could be held by the state, but not necessarily so. And in particular, he worried about the power that was accorded to corporations. He referred to them as worms in the entrails of the natural man, which is just beautiful. And he said, you know, there should only be one form of Leviathan, the form of the state. And he feared that the kind of parasitic power that was wielded by the corporations was going to threaten the sovereignty of the state, and we're all, you know, descending into chaos. And it wasn't merely a theoretical concern, because the anxiety that he had was manifesting in the international context at the time. We had our first corporate sovereigns, the Charter Corporation. And these corporations, like prominently the Dutch East India Company and the English East India Company, had a lot of the sovereign powers which Hobbes said should be in the sole purview of the state. So they were granted powers to wage war, enter into treaties, establish settlements, and govern colonies. And the accepted kind of narrative of the corporation at this time was that it was a tool of colonialism, of state colonialism. But the resulting relationship between the state and the corporation was actually very complex. So as creatures of legislation, they were regarded as tools of the state. The kind of life of the corporation was governed by the life of the charter: state give, state take away, life ended. But at the same time, there was a necessary degree of separation between the entities. And this was because there was this emerging legal fiction of equal sovereign states and, you know, no external interference. And so the use of the corporation to wage war and dispossess land kind of meant that you wanted this little degree of separation. So it kind of fostered this additional legal fiction that corporations were, you know, kind of something else. And this kind of had unintended consequences, because it meant the corporation got more powerful and more autonomous. And they got so autonomous and so powerful that it reached the point where they were, you know, controlling vast regions and eventually ruled India independently. And this real power obviously caused real harm. A really stark example is the Great Bengal Famine in 1770, where under the British East India Company, over 10 million people starved. So the operations of these trading corporations in the modern era didn't go unremarked or uncritiqued. Critique came from quite well-known Enlightenment thinkers of the age. So writing within the context of colonialism, Immanuel Kant suggested reforms to the content of international law that would constrain the activities of European states and the corporations in other territories. And so responding to increasing cross-border interconnection at the time, he said, you know, ships and camels, the ships of the desert, had enabled men to kind of, you know, go forth over these tracts. He observed that states and trading corporations didn't necessarily behave well beyond their borders. Citing the example of the East Indies, he argued that the setting up of trading posts ended with the widespread oppression of the inhabitants, and a whole litany of troubles that oppress the human race. And so he believed that this depravity would only end if the kind of commercial states and trading corporations who were pious in their orthodoxy but drank wrongfulness like water, were subject to these kind of universal public laws which constrained their operations. And he was really scathing about international law that existed at the time and the kind of international legal theorists of the time. And he took a direct swing at Grotius, who was obviously, you know, not great. And the sorry comforter, that's the famous quote, of a system that permitted states and corporations to commit grave harms all over the world. And at a similar time, you had Jeremy Bentham in the UK, who was launching a direct attack on the sovereignty of the British East India Company as kind of arbitrary despots and advising the British government to do something about it. And this fed into the kind of broad charter debates and eventually the dissolution of the charter model in the 19th century. So at the end of the 18th century, the British Crown was already taking their first steps to gaining control back of India. And in the mid-19th century, that's what they did. But the model didn't disappear overnight. It was still utilized by the British in the scramble for Africa at the end of the 19th century. But what you notice here is that there was a bit of a shift because corporations were like kept far more on the leash than they were. There was quite a notable consolidation of sovereignty at the end of the 19th century, of state sovereignty, I should say. And this shift coincided with ideological changes on the nature of the corporation that were happening in domestic law. So corporate individualism took hold and corporations were reclassified as private actors, which led to this public-private divide. They weren't, and it was then obviously reflected back into the kind of international context. So this meant that the corporation was kind of delinked from explicit state purposes. But it also meant that the state was then left as the sole subject of international law. So this was, you know, conducive to state interests, but it also meant that it kind of shielded the corporation from accountability for harm they were causing, because they were no longer, you know, these kind of sovereign entities and subjects under international law. And so in this respect, García has argued that with the rise of the public-private divide in international law, the discourse of responsibility was situated within the constitutional political part of international law, whilst corporate activity was enclosed in the private domain, resulting in significant ideological hurdle that must be overcome before one can be associated with the other. And the result was a relative silence about corporate accountability until you get to like the mid-late 20th century. Obviously, as Professor Angie said, you know, we had, in the context of decolonization, discussions, like in the context of the new economic order. But it was the 1990s when the conversation about business and human rights really kicked off. And that was as a response to the negative effects of globalization and commercial liberalization. So the emergence of the neoliberal ideology at the end of the 20th century led to the introduction of countless rules and rulings which kind of pushed forward the economic globalization kind of program and strengthened corporate rights. There were more multinationals than ever before. And anecdotally, as their operations expanded, so did their human rights abuses. And so in response, there were these various attempts in international law to hold corporations accountable. But falling into this whole public-private divide, they took the indirect approach. And my argument is that this ignores the increasingly sovereign-like powers that multinational corporations are wielding, which often eclipses the power of the states which they are operating in, but also the states from which they are domiciled. So how long do I have? 2 minutes? Okay, very quick. Yeah, so the primary example is that is the power that corporations wield over host states with less resources and kind of weaker governance structures. And as a solution, contemporary scholars often turn to extraterritorial obligations. But my argument is that this is not necessarily a sufficient solution. And that's because often the power of multinationals also overwhelms the power of the state from which they're domiciled. And there's a couple of elements of that story. Like one is the states kind of have to compete for favorable conditions. So there's like this regulatory race to the bottom in order to get corporations to domicile. But also another aspect of this story is just how multinationals actually operate today. So it's a reality that needs to be confronted, that large and phenomenally wealthy companies increasingly conduct business on the global level, which is beyond the regulatory reach and capacity of many states. I'm going to do 1, 2, skip a few, 99, 100. But my basic argument, which I make at the end of the paper, is I kind of revive a neo-Kantian argument. This is all brought about by kind of increased interconnection and economic globalization, which has led to corporations acting as modern variations of corporate sovereigns and causing harm to human rights, which provides the normative impetus to kind of hold corporations directly accountable. I think this argument is intuitively powerful when located within the history of corporate sovereignty. I think, few people would kind of defend the operations of the charter corporations. And so to the extent that we can draw analogies, I think it's quite powerful. But I also consider whether, for the sake of human rights, we should look beyond human rights and deal with it as a kind of systemic or structural issue, which obviously the problem of the multinational corporation is. And kind of perhaps look outside of the box of business and human rights to other solutions. The general conclusion that I seek to draw is that if contemporary corporations are acting as corporate sovereigns, then proposals to impose limitations on corporate sovereignty become not only the logical conclusion, but also should be the principled response.
We have moved in this panel from dignity to state responsibility to corporate responsibility, and now we are going towards questions of universality. And for that, we have Dr. Gabriela García Escobar, Professor of Public International Law from the Universidad Panamericana, and she will be talking about 2 models of universality. What are the prospects for human rights in the fragmented world?
Thank you. So I would like to begin my intervention recalling one of the statements made by Professor Angie, that we live in a really confusing world. We live in a world where human rights universality is constantly challenged. On the one hand, we have a new multipolar world order. We have the crisis of liberal democracy, and we have deep moral disagreements within societies, both in Western and non-Western contexts. In the other hand, we have the fragmentation of international law and also the internal fragmentation of international human rights law, where we find that different protection mechanisms have adopted contradictory views on substantive issues on human rights. So it seems that the disagreements on key human rights issues is deeper than it seems. What I propose in this paper is that a closer examination to this situation reveals that the notion of universality, paradoxically, is not universally shared. And I think that this is because the concept of universality can actually be analyzed from different perspectives. I identified 3 main perspectives in an article that was published in 2023 in the journal Global Jurist. And these 3 perspectives are: 1, from the point of view of who is the rights holder, who is the subject of human rights. And here we have different debates about the definition of who is the individual, who is the person, who is the human person, and these different acceptions contain different definitions and exclusion of who is the rights holder of human rights. The second point of view to analyze the issue of universality is the concept itself of human rights, whether the concept of human rights as a whole is universally shared or whether this is a construct that belongs to certain cultures. And then we have a third perspective, that is a perspective regarding the interpretations or the standards that have been adopted of human rights. The focus of my intervention will be on this third perspective, because I think that most of the debates that have been generated around the human rights issues are about the creation of new rights and morally sensitive issues. And this whole debate has to do with the interpretations or the standards that have been adopted by different international mechanisms of human rights protection. So to understand what is the universality regarding the interpretations or the standards that I call interpretative universality, we have to make a subtle but essential distinction between internationally recognized norms and interpretations or standards. So internationally recognized norms are broad and general norms that are established in one of the main sources, one of the formal sources of international law, that is treaties. So conventional norms are adopted through a lengthy process of negotiation between different states that represent different social, political, cultural, and religious systems. And this means that in order for a text to be acceptable to a wide variety of different states, the terms contained in the treaty have to be broad enough in order to encompass these different cultures. On the other hand, we have the interpretations or the standards. And these interpretations or standards, they are constructed to a process of legal interpretation and legal argumentation that is conducted by a specific interpreter, an interpreter who through his or her experience and knowledge determines the scope, the content, and the limits of these general norms in concrete context. So in light of this distinction, I identify two different positions regarding the interpretative universality of human rights. So first, we have the liberal or the uniform universality. I think that in the European context, we can change liberal for neoliberal or for hyper-liberal universality. And on the other hand, we have the pluralistic or the flexible universality. Okay, so first, the uniform or the liberal universality. This position refers to an interpretative paradigm that proposes defining the concept and the scope of human rights in terms of an individualistic anthropological conception that is derived from the philosophy of liberalism. And it proposed to adopt this vision in all societies, in all areas of human activity, because the exercise of full personal autonomy should be privileged over any other good or value in society. To achieve this goal, this paradigm does not consider the various cultural, social, and religious contexts and goods as parameters or frames of reference for determining the content and the limits of human rights. On the contrary, these elements are mostly perceived as barriers or obstacles to the full realization of individual rights. For this reason, the proponents of this vision assume a negative perception of society's social and cultural norms, which also implies a precautionary approach to local legal systems. Thus, this proposal establishes a hierarchical relationship between international and national law and between international and national courts, with the former taking precedence over the latter. This view assumes that the ultimate interpreters of international human rights law are international courts, so they must unilaterally and vertically decide which standards or interpretations are going to be chosen as the universal ones. Under these premises, the most important and hierarchically superior source of law in international human rights law will become the most recent jurisprudence of international courts. Therefore, the norms of international treaties and international customary norms, the formal sources of international law, together with principles, will become secondary means for the determination of law. In this paradigm, then, a process of deformalization of international law is encouraged. Therefore, on these premises, the role of an international court is to determine what is decidable to be incorporated into local legal systems as universal norms, even if there is no international consensus on the issue. In other words, the model is based on an aspirational model of universality, and the role of the international judge is to transform local societies so they can adopt the interpretations decided by the international sphere. On the other hand, we have the pluralistic or the flexible universality. This paradigm operates under very different philosophical premises. Actually, this paradigm shares the premises originally adopted by the drafters of the Universal Declaration of Human Rights of 1948. According to these premises, the universality of human rights must be determined horizontally and interculturally through consensus among different cultural and philosophical traditions. Therefore, only those interpretations that are common or shared by different states and that reflect a solid consensus within a large number of different societies can be considered as universal. Otherwise, the standards agreed by some states will only be imposed as universal standards and then rejected by the rest of the international community. Thus, the premises of this paradigm of pluralistic or flexible universality implies that there are three important consequences for the purposes of interpretative universality. The first one is that the core of human rights are internationally recognized norms as established in treaties, but their implementation and interpretation is flexible enough to adapt to different social, cultural, political, and economic contexts. The second implication is that this minimalist approach, based on the transversal agreement between cultures, implies that the states enjoyed a wide margin of maneuver to regulate issues that are not specified in international treaties. And finally, the last implication is that the most relevant sources of law remain the traditional ones, customary law and treaties. Thus, if there is no clear international consensus on a human rights issue, if it is not explicitly regulated in a treaty, it cannot be considered as universal and it cannot be uniformly applied to all societies. Accordingly, according to the premises of this second paradigm, the role of an international court will be to conduct a cross-cultural analysis to determine whether a given interpretation enjoys universality, horizontal universality, or not. The international court is not superior to national courts in this paradigm, but rather engages in a dialogue in which local evidence is sought to determine whether or not there is consensus on the issue under consideration or not. In the absence of consensus, the role of the international court is to recognize the degree of deference that each state enjoys in regulating the issue at stake. So according to these two paradigms of the interpretative universality of human rights, I identified true doctrines that have been developed in the jurisprudence of two international human rights courts. So the first doctrine that we are going to analyze refers to the conventionality control. So the conventionality control is a doctrine that has been developed in the jurisprudence of the Inter-American Court of Human Rights in the Inter-American System of Human Rights Protection. And this doctrine was first adopted in the case of Almonacid Arellano versus Chile in 2006. This doctrine establishes that as part of the obligations contained in the American Convention on Human Rights, states parties to this treaty, this is the foundational treaty of the human rights system in the Inter-American system, states parties, through their judiciary and all other organs of the states, have the obligation to exercise what is called a control of conventionality that is similar to the control of constitutionality that is applied in some domestic systems. And this control has to be conducted between the domestic legislation of each state and the American Convention of Human Rights. But the controversial aspect, and there is a lot of literature on this, about the conventionality control is that the Inter-American Court of Human Rights has required to conduct this control of conventionality not only between the domestic legislation and the obligations established in the American Convention of Human Rights, but also between the domestic legislation of each state and the interpretations adopted by the Inter-American Court of Human Rights, and that includes the interpretation established in the contentious jurisdiction of the Inter-American Court, but also in its advisory function and in any official pronouncement. This includes, for example, press communications. In these terms, the Inter-American Court of Human Rights refers to itself as the ultimate interpreter of the American Convention on Human Rights. The conventionality control, as can be seen, is based on the premises of the model of uniform or liberal universality, as it proposes a relationship of superiority between national courts and the Inter-American Court of Human Rights, and it establishes that the determination of the universality of human rights standards or interpretation is a unilateral, vertical, and aspirational task. For example, the Inter-American Court of Human Rights has been reluctant to conduct systematic analysis of comparative law in the region, and in some cases, this court has expressed that the absence of consensus on sensitive issues not regulated by the American Convention of Human Rights is totally irrelevant for the adoption of a new human right or for the extensive interpretation of existing human rights. Accordingly, as some authors have pointed out, the evident consequence is that the jurisprudence of the Inter-American Court of Human Rights becomes the primary source for determining human rights standards and therefore human rights interpretative universality, even in contradiction to international customary law or consensus, as the Inter-American Court itself has pointed out. The second jurisprudentially developed mechanism that we are going to analyze is the margin of appreciation, adopted by the European Court of Human Rights, that I think most of the audience here is more familiar with this. So the margin of appreciation can be broadly defined as the latitude granted to state parties to the European Convention on Human Rights to evaluate contextual situations and to comply with their own international obligations. This doctrine implies a degree of prudence and judicial self-restraint on the part of the European Court of Human Rights, allowing states to consider and balance various collective goods when implementing their international obligations, and to interpret vague and general clauses in the light of each state's political, social, and cultural context. This margin has been adopted as one of the steps to be evaluated in the proportionality test to determine whether a state's measure constitutes a legitimate restriction to a human right or, on the contrary, whether it violates a human right. This doctrine implies that the state must provide relevant reasons for its actions, discuss alternatives to less intrusive measures, and determine what constitutes a pressing social issue, a pressing social need in each circumstance. According to the jurisprudence of the European Court of Human Rights, this margin of appreciation will be wider when there is no consolidated European consensus on the issue, and when morally sensitive issues are analyzed. As can be seen, this doctrine is based on the same philosophical premises as the pluralistic or the flexible universality. The room for pondering and maneuvering granted to states assumes that human rights norms establish generic concepts that can be materialized in different cultural contexts and in response to different social needs. Therefore, the decision of which interpretations to adopt and those not to adopt does not rest unilaterally with the judges of the European Court of Human Rights in a relationship of superiority vis-à-vis with the national legal system, as in the case of the conventionality control. But rather, the International Court acts in a horizontal manner as it establishes a dialogue and a complementary relationship between local legal systems and the international level. In this sense, the International Court cannot adopt as universal an interpretation that is not supported by a wide international consensus. Therefore, here international customary law acquires a preponderant role as a legal source, as the traditional doctrine of sources establishes, so that the standards are decided transversally, taking into account the objections and the circumstances of all different states. So from the analysis of these two paradigms of universality and these two judicially established doctrines of universality, which is the model that is more suitable or that is more appropriate for our new multipolar world. I think that something that we should take into account is, as Martti Koskiniemi said, we live in a world of international law between apology and utopia. So we have, on the one hand, raw politics, and in the other, we have aspirational global values to protect our common humanity. So I think that we have to balance the possibilities and the limits of both paradigms of universality. Thank you very much.